mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection.
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe in afternoon.
And those are 2 ICF forms?
Yeah, one addressed to you directly and one addressed to District Attorney's Office.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a mood issue.
I don't believe it's a mood issue. And I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing it's a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
Thank you. The Inspector Schultz's mechanical inspection report was provided to the defense on April 29, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel. I did not have it for quite some time. Let me make my record. Either through counsel. It was just told to me. That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me,
it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and I'm
telling
going to
you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
from the state to be
addressed, Your
provided
Honor.
to the state. Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so,
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like you're-
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem like
ask that you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to
need
give you
you-
advisements, sir, regarding your right to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a witness
through,
to
you
call,
don't need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You are
I'm merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've
forfeiting
said that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
standards
because
of
it
decorum and
doesn't.
civility, and
Illinois
one of the
doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being interrupted.
does not
We'll clear
state
the courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again,
It
I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit
Thank you.
agreement for something that I.
Madam Clerk, may I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute, though, and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse, to call today? I need an answer to that question, sir.
addressing subject matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is
that
my audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
What you talking about?
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir. I've
You are
confirmed.
lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself, I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. You can speak directly to you. I'm trying to hear it. Can you hear it?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying, so cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear, and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants, he takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision?